be reversed. Thank you, Your Honor.
May it please the Court, Natascia Ayers on behalf of Jessica Leone. One point that I think counsel skips over is the trial judge determined that the petition was filed within a reasonable amount of time, giving Health and Hospitals Corporation notice of the claim, and that is within the sound discretion of the court. That's the first point, and that's not really addressed. They just, the Health and Hospitals Corporation is saying, well, that's just too much time. The court in their discretion said that was enough time. And in looking at the medical records on their face, even not considering the pathology report, the records show that she had a mass forming, getting larger in her face when she presented during those 3 visits to the hospital. There was swelling, painful, it was oozing from the wound. She had been on 2 rounds of antibiotics and still not healing. In the face of a person who had already been diagnosed with basal cell carcinoma, and that is in their records, how is it that a doctor cannot perform a differential diagnosis and rule out the most life-threatening of conditions instead of assuming that it's an infection? There was nothing done. The face of these records show a mass there. And it was incumbent upon those doctors to rule out that the basal cell had not been totally excised or had come back. And that is what Dr. Melman, our expert, had said. So looking at point 1, there was a reasonable amount of time that the city was given notice. There's a petition filed in November. Meanwhile, while this petitioner, this patient, was fighting for her life. She filed a claim while she was undergoing radiation. She lost part of her face. She had reconstructive surgery on her face. It failed. She was undergoing radiation, seeking pain management, and went to an attorney, filed the petition, and made the claim. The court found there was a reasonable excuse. There was not one iota of prejudice. They didn't attempt to take a 50H. There was no interview by doctors or any statement by anybody saying that the doctors are no longer available. There was no attempt to even try to investigate this claim so that the argument could be made that there was prejudice. There's 0 evidence of prejudice, and that's what the trial court decided in deciding to accept the late notice of claim, because certainly 9 months to know of a claim is sufficient in this case. And months later, when she decided to go to a different hospital to assess her claim, and they picked it up and underwent surgery. This was at month 4 that it was discovered. And to say that a person she didn't even know of the cancer until after the 90 days had elapsed. So there was no way for her to have made a notice of claim within 90 days because she wasn't aware of the cancer until she returned and went to a different hospital, and they did the right thing. They took the biopsy, and it was diagnosed. So this decision was right. This claim should continue. And thank you, Your Honors.
Thank you very much. I know number 16 was marked submitted, but is there anyone here on number 16?